I've made a small address for you so that you know how law works for you and how aware you should be about implementing it in your favor. Never take sexual harassment lying low. That's my motto. Good afternoon, ladies and gentlemen. Good afternoon. And also Ms. Gagan Bhargava and Mr. Dr. Morrow. It is my great pleasure to talk about diversity and inclusion and can India maximize corporate power from diverse workplace. Topic I'll be speaking today is on gender diversity. As you all know and aware that men and women together make the society wheel move forward. Long back, women have crossed traditional role of homemaker, and today she is equal breadwinner for her family. A woman tries to contribute in every possible way. However, society is still biased, with prejudices against working women and women as a whole. This brings us to issues that I'm going to discuss today with you. It is a sensitive issue, a very sensitive issue indeed. Sexual harassment of women at workplace. Sexual harassment at workplace is a growing issue and is viewed as employment discrimination. The work environment is laden with hostile environment. Hostile environment at workplace is a widespread and ranges from lofty attitudes, employment discrimination in the form of unequal pay, delayed promotions, to sly remarks on plight of spouses or working women, comments on women's attire and appearances, etc. The journey towards curbing the menace in India started in a small hamlet in the state of Rajasthan by a woman called Banwari Devi, which ultimately culminated in the form of guidelines given by the Honorable Supreme Court of India in a case titled Vishaka versus State of Rajasthan. Before this decision, there was no law preventing this heinous crime, that is sexual harassment, and of course at workplace in India. Sexual harassment was not regulated by any of the labor or employment legislations. The only redressal was in the form of criminal law provisions under the Indian Penal Code, IPC. Section 509 of the IPC states that any word, gesture, or act intended to insult the modesty of a woman is an offense, and Section 5354 creates an offense out of any act that outrages the modesty of a woman. But these are not actually used to address the problem of sexual harassment in the workplace. Actually not. In the Banwari Devi's case, she was a social worker, a Sathan of a development program in the state of Rajasthan. She opposed child marriages. She tried to stop one Ram Karan Gujjar from marrying off her only infant daughter. Despite her efforts to stop the marriage took place. Banwari Devi was socially boycotted for opposing child marriages. Then in September 1992, she was gang-raped by 5 men, including Ram Karan Gujjar. It violates a fundamental right, Article 21 of the Constitution, guaranteed under the Constitution of India, equality under the Articles 14 and 15 of the Constitution, and the right to practice any profession or to carry out any trade or businesses are protected under Article 91G of the Constitution. The right to life was interpreted to mean right to life with dignity. The Supreme Court held that gender equality includes protection from sexual harassment and the right to work with dignity, which is a universally recognized basic human right. These guidelines are mandatory in nature. Under these guidelines, employers are under obligation, yes, they are under obligation, to provide safe work environment for women free from any sort of sexual harassment. Thus, a positive duty, responsibility, obligation is casted upon employers to create an environment which is safe for work for women at workplaces. These guidelines are preventive in nature. It requires employers to be proactive. These guidelines apply to both organized and unorganized work sectors, private and public sector, and to all women working part-time, on contract, or in voluntary honorary capacity, even students from professors. This judgment makes mandatory for all organizations, which includes corporates, to have dedicated redressal cell for sexual harassment at workplace. I'm happy to find that big corporates, especially multinationals, have sexual harassment policy in place, but many need to have these in places, which is not in place so far and which is really shocking. Another case that reached Supreme Court is that of sexual harassment of a clerk cum typist of a private secretary to the chairman of the Apparel Export Promotion Council in India. It was alleged that the private secretary to the chairman tried to molest Miss X, working as a clerk cum typist. She was forced to attend a meeting, and instead of her repeated requests and objections, he misbehaved with her. She met director personnel the next day and narrated the whole incident to him orally and submitted a written complaint too. The respondent was placed under suspension and a charge sheet was served to him, to which he gave a reply obviously denying the allegations. A director of the council was appointed as an inquiry officer to inquire into the changes and the charges framed against the respondent on behalf of the management, with a view to prove the charges. As many as 6 witnesses were examined, including Ms. X. The respondent was also requested and was also allowed to examine 7 witnesses. The inquiry officer, after considering the documentary and the oral evidence and the circumstances of the case, arrived at the conclusion that the respondent had acted against the moral sanctions and that his acts against Ms. X did not withstand the test of decency and modesty. He therefore held the charges leveled against the respondent as proved, which was upheld by the Supreme Court of India. Yet, another case which went in favor of women teacher in army school who was harassed by employer, and even in case of foreign allied staff, which went in favor of the lady who alleged harassment. Thus, it becomes imperative to understand what constitutes sexual harassment is a question mark. You should all understand. Under the judgment, Honorable Court defined any of the following unwelcome acts as an act of sexual harassment. That is, physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography or any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. The term sexual harassment is of very wide connotation. It can be classified into 2 broad categories. First is hostile work environment, and second is quid pro quo, that is making the conditions essential for work benefits. However, executives need to remember that the key term in definition of sexual harassment is unwelcome. It is this term which constitutes whether behavior constitutes sexual harassment or a consenting one by recipient. According to Vishaka guidelines, the following behavior amongst others causes sexual harassment at workplace. I will speak point-wise. First, if a person subjects another person to an unwelcome act of physical intimacy like grabbing, brushing, touching, pinching, etc. It will not be out of place to mention that in case of KPS Gill and Deepak Bajaj, male IPS officer was taken to task by the courts for bottom slapping. Second is, if a person makes an unwelcome demand or a request, whether directly or by implication, for sexual favors from another person. The friends aggravates if he makes it conditioned precedent for employment or for promotion or for any other hike. Here I would like to mention a case which has come recently to me where a lady bashed her employer for sexual overtune and then literally grabbed her for physical contact. But what is more alarming is the fact that she told me that she had to leave 3 MNCs, tempting jobs where she qualified 100%, only for the reason that while during the interview she was told that she would consent to everything asked for from her by the bosses, which is a conditioned precedent for employment, for her employment. She obviously refused and left the interview table. There should be some method to stop this. A third party, maybe an NGO or any other mediator, should be made to sit while interviews are in progress, which should be made mandatory so that innocent girls in need are not forced into silent sexual harassment or silent prostitution while getting mentally shattered from within the entire persona. Next, if any person makes an unwelcome remark with sexual connotations, these connotation includes unwelcome sexually explicit compliments, sexually discriminating jokes, talking or commenting about passer-by, or simply cracking sexual jokes, or making sexist remarks, etc. Next, if a person shows to another person any form of sexually explicit visual material, then again it constitutes sexual harassment. However, it has to be unwelcome viewing of these materials. These sexually explicit visual materials can be in the form of videos, pictures, sketch, calendars, screensavers, desktop picture, skin cover of laptop. Another form of text which is offensive in nature and unwelcomed. This includes written material and electronically written material. If a person engages in any other unwelcome conduct of a sexual nature, this can be verbal or non-verbal. This includes vulgar gestures, staring to make the other person uncomfortable, kissing sounds, etc. Further, it is to be remembered that in today's e-age, definition of workplace has expanded significantly. The physical location and boundaries of the work premises doesn't only constitute workplace, but includes every situation where employee-employer relationship subsists. Well, I'm short of, I think, I'm taking too much time, so I'll just go to the end of the thing. And I hope you all understand what Vishaka means to all of us. It is a judgment which everyone should know about and should know that you should not take things lying low. You should always express your views whenever you are on an interview table or whether you're at workplace. Nothing is so important than your own self-respect. And then there is this judgment which is very much important to all of us, and there are many other judgments of the like. Well, there are other things which I just wanted to mention, like eve-teasing, unsavory remarks, jokes causing or likely to cause awkwardness or embarrassment, suggestions and taunts, gender-based insults and sexual remarks, unwelcome sexual overtones in any manner such as over telephone, obnoxious telephone calls and the like, touching or bruising against any part of the body and the like, displaying pornographic or other offensive derogatory pictures, cartoons, pamphlets or same. All these things include all this: eve-teasing, sexual harassment of the employee while at work. I'll just come to the end of it. India till date doesn't have effective legislation to tackle sexual harassment at workplace. The drafting process has initiated by the National Commission of Women, and finally a draft law known as the Protection of Women Against Sexual Harassment at Workplace, Bill 2006, was prepared by the legislature. However, it lapsed. Recently, a new version of the bill titled the Protection of Women Against Sexual Harassment at Workplace, Bill 2010, was tabled in Parliament, which imposes penalties on victim if the complaint of sexual harassment is not proved. However, this bill titled is also drawing flack. It does not cover domestic helpers and the bill is pending for consideration. Thus, till date, these guidelines from the Supreme Court are the law of the land and it is the need of the hour to adopt the same. Thank you.